If any persons to the number of 12 or more, being unlawfully, riotously, and tumultuously assembled together to the disturbance of the public peace at any time after the passing of this act, and being required or commanded by any one or more justice or justices of the parish or place where such assembly shall be, by proclamation to be made in the Queen's name, in the form hereinafter directed, to disperse themselves and peaceably to depart to their habitations or to their lawful business, shall, to the number of 12 or more, notwithstanding such proclamation made, unlawfully, riotously, and tumultuously remain or continue together by the space of 1 hour after such command or request made by proclamation, then such continuing together to the number of 12 or more after such command or request made by proclamation shall be adjudged felony, and the offenders therein shall, upon conviction, be liable at the discretion of the court, be imprisoned for life with or without hard labor.
May it please you, my Lord Chief Justice. My Lord, I am somewhat affected. Just that one of our colleagues, Horace, former Parish Court, that he has just tried after having it COVID-19. Say that I am discombobulated, my Lord Chief. I knew time he was dark, as I'm sure was a most pleasant and very, and may I, on behalf of the Office of the DP, my colleagues there, not only in respect of Mr. Stanley Clark, a former senior Parish Court judge, who I knew from his days at the Attorney General. May I, on behalf of my office, offer my condolences to you, Chief Justice, and your colleague on the passing of Mr. Stanley Clark, the Parish Court Judge, and on the passing of Parish Court. I am for. And I see my learned friends from the private bar here, Mr. Peter Schreiber, because at the private bar, they too have had colleagues of ours, transition over the last year and a half because of COVID-19. And I too offer my condolences to them on behalf of the officer in respect of the passing of our colleagues. Now to the business of the day, my Lord. Our list, as we have collated, officer, has shown that there have been some 84 committals for the Michaelmas term, and that in terms of matters traversed from the last term, we have about 907, and that in all, in respect of the number of cases, it is a little bit over 1,000. In fact, we have about 1,000. My Lord Chief Justice, since you have made it quite clear that of trial date at the center of the administration and at the office of the DP have policy wholeheartedly, and we have sought to faithfully administer prosecution of the matters, mindful of the fact that in effect we have to. So my staff and I are well aware of that, and we have been working with the effect of making as far as is by cases. Now, in this dispensation, which commenced from last year, March, April, with the onset of the pandemic, COVID-19, we have had to push forward a lot of cases that were on the trial list because my learned friends at the private bar did indicate, for the most part, that they would prefer to have these matters tried by jury as opposed to judge alone. However, I must here recognize the cooperation, though it could have been a little bit more, of my learned friends, where we have been able to dispose of matters, whether by way of trial by judge alone, entering of nolle prosecution, appropriate case, and also offering no evidence, not be able, where the Crown would not be able to put up a viable case. And here I have to thank your Lordship for the very detailed and clear practice direction that your Lordship has offered from the commencement of this pandemic, which have been reviewed from time to time, giving very good guidance in respect of how to manage our case lists with the pandemic, as well as adhere to the government protocols. I would, however, use this opportunity to ask my learned friends at the private bar to consider or to reconsider that in light of the fact that we are now currently having a surge in the COVID-19 figures, that they liaise with their clients, especially the clients who are in custody, to seek to prevail upon them. That where trial dates have been set, that though they may have desired having a jury trial, that they seriously consider having judge alone trials. And we are available for constant discussion with the private bar, and I know that the bench would not be averse. So in terms of case management, in respect of making every accommodation for a change of mind as it relates to trial of cases. And here I have to also recognize the excellent leadership that my Lord Chief Justice you have given as chair of for want of a better way of putting it, the COVID-19 committee, which you have convened from time to time, which is a committee under your chairmanship, which is comprised of stakeholders in the justice systems. We have the police, we have the corrections department, we have the private bar from different regions in the country, we have the office of the DP, we have the parish courts, senior judges who are on this committee. And it is important that the public knows that the administration of justice, certainly under your chairmanship, has sought to be proactive in terms of taking a realistic in respect of this whole issue of being able to return to jury trials. But I'm sure your lordship will elaborate on that. But certainly, speaking for myself, I wish to thank your lordship for having convened this committee and for the constant scrutiny and consideration that you give in what is a very difficult time for all of us as leaders in our particular spheres of endeavor. I would wish to take this opportunity to thank the other stakeholders, the police, who have not hesitated. I know that they are under a tremendous amount of pressure, having to police the army protocols or the law and decide when they exercise their discretion and when they have to arrest and charge. I would like to thank the corrections department, who have been very accommodating and responsive. And both stakeholders have tried to make sure that we are able to operate virtually in terms of making sure that along with the Supreme Court, the Office of the DPP, and the private bar, we are able to do the public's business in keeping the wheels of justice turning. I understand that about out of the approximately 1,000 cases that we have on the list for the Michaelmas term, based on your lordship's policies and trial date certainty, we have approximately 120 cases set for trial. And it's important the public understand that although we may have 1,000 cases approximately for the Michaelmas term, but in reality, only about 120 cases are set for trial in terms of the circuit matters, and we have another set of cases, perhaps another 100 and odd cases, set in the gun court over the entire Michaelmas term from September to December. And we have, in terms of trying to be operationally and administratively astute, again under your lordship's leadership, we have trial cases being set into perhaps the next 2 years to make sure that when the matters come up, both the defense and the prosecution know that we either put up or shut up. And we can only hope that that will assuage the concerns of a public which clamors for transparency and accountability, to see that within the exigencies of our circumstances, we are trying to make sure that when a trial date is set, then they will be able to have the matter tried. But my Lord Chief Justice, enter the pandemic, and it has really set the cat among the pigeons, and it has stretched, I believe, every leader in any sector, and I suspect this is worldwide. We have had to think outside the box. We have had to balance and deal with a multiplicity of issues and challenges which surround how to keep the workspace safe for all concerned, and this is for both the vaccinated and the unvaccinated. We have had to be responsive to the human resource concerns and sensitivities in relation to dealing with vaccine hesitancy, dealing with persons who do not wish to be vaccinated in circumstances where there is no mandate. So Speaking from my office, I would indicate for the record that so far we are, I would say, about 60% in an office complement of nearly 100, 60% vaccinated, and we are embarking on a program of public education to make sure that all members of staff have the information that they need to make that personal decision in respect of whether to vaccinate or not to vaccinate. We too have had to deal with situations where persons have had to go into quarantine. We have had a couple of persons who have proved to be positive, and we have protocols in place to make sure that the wheels of justice, that the courts are able to continue. So we have a person, if there is a suspicion that they may have been exposed, they are tested, and if it is that they have to go into quarantine, we try as best as possible to send a replacement. My Lord, I believe that I would have to say that what has been keeping a lot of us is our commitment to service above self, and I make no apology for it. I embrace it because this is what keeps me going in these very difficult times. And on behalf of my office, I pledge that we will endeavor to try to make sure that we continue to discharge our responsibilities under the Constitution as a prosecuting service operating in the public interest. Because as I remind myself every day, especially when I have to deal with the challenges, it is not the public of Jamaica who is serving us, but we are here to serve the public. And as best as we can in the circumstances, we are duty-bound, notwithstanding the difficulties presented by COVID, to try to give of our best 100% of the time, as long as we are positioned in this space. And may I indicate, just for the record, that on the list for this term, there is a 32-man case in respect of the offenses under the anti-gang legislation. 4 prosecutors have been assigned, and the Crown is ready in the matter. I think it is on the trial list to commence next week, but for the record, I would indicate that the Crown is ready. So finally, my Lord Chief Justice, again, my condolences to the family, the colleagues, and the friends of Mr. Stanley Clark, Mr. Horace Mitchell, and also attorneys at law at the private bar. I was so very, very discombobulated, so saddened to hear about the most recent transitions in Mr. Howard Hamilton, Queen's Counsel, Mr. Ernest Smith. It is just getting so numerous. But I think we all have to just treasure the memories that we have of all these individuals who, in the final analysis, my Lord Chief Justice, chose this noble profession of the law, and they gave it their best. I think I should also offer condolences to the police, because I have heard and seen in the public space reports of police who have transitioned because of COVID. In fact, it would appear to me that every profession, every occupation is now being touched where persons are transitioning. But it behoves all of us during this pandemic to have collective broad backs, to be sensitive to the plights of our fellow persons, but nonetheless, we have to be mentally tough and to continue to soldier on, because we are public servants charged with the responsibility to serve the public to the best of our ability. May it please you, my lord.
Thank you very much, Director. Yes, Queen's Counsel.
May it please you, my Lord Chief Justice, I would wish to start by joining in the sentiments expressed by Learned Director of Public Prosecutions, Queen's Counsel, Ms. Llewellyn, in terms of the persons that have transitioned. Our condolences on behalf of the private bar to all of those that have been affected by this horrible disease. My Lord, I think what is perhaps very poignant is the fact that in reflecting, there is to date rather, no less than 30 persons associated with the legal fraternity that have either died as a result of COVID or because of the COVID restrictions in terms of funerals, we are not able to celebrate in a very meaningful way the life and legacy of many of those persons. And that, to my mind, is heartrending because in some instances it is just by way of a note or a public announcement in relation to the passing of some of these personalities, larger than life, and that is the extent of it. We don't know of any funeral arrangements, and in the Jamaican sense, in terms of going to celebrate the life and offering support to the family members, we are not able to do so, so it is doubly hard. My Lord, as it relates to the whole issue of jury trials and bench trials, perhaps analogous to the vaccine hesitancy is the hesitancy of some members of the private bar, defense bar, to embrace the concept of bench trials. And I would make bold to say that I am of the view that our associations need to be more proactive in sensitizing members of the defense bar and to remind us, and them rather, of the fact that we are here to offer counsel. We are not to impose our personal preferences in terms of the modality of trial, and we are to explain in great detail the benefits and virtues in terms of each process. It is important, I think, to note also that despite the challenging periods in the pandemic, the court has discharged itself quite well in terms of the disposal of matters, particularly as it relates to the gun court. The opportunity has been utilized to a large measure, reduce the backlog in an amazing way. So it is not all doom and gloom, my Lord, and I would wish to commend the stakeholders and encourage my colleagues to continue in this effort, because the justice system is an important feature in any society, and the proper functioning of it, it's very critical. My Lord, what is left to be said is that in all of the circumstances, I would, on behalf of those who are willing and able to come out and to participate, I would pledge that we will undertake to do our part. We have said it time and time again, but I think more so than ever, it is important that this be not just mere words, but be demonstrated in terms of actions. So, my Lord, again, I end by where I started. My condolences to the judiciary, the members of the private bar, and to the wider society in terms of the stakeholders in the justice system, police officers, relatives who are affected by this pandemic. May it so please you, my Lord.
May it so please you, my Lord. I first bring greetings and apologies on behalf of Mr. Alexander Williams, who would have like to be here this morning as the current president of the Bar Association, but he regrets that he's unable to attend this morning. I endorse all that Learned Queen's Counsel on both sides of the bar, prosecutorial and the defense bar, have said. And as I was thinking about what to say this morning, my lord, two things came to me. As we have had this national and indeed global debate about vaccine mandates, it has become more and more important for one to look at the law and the Constitution. I have not seen before so many people opining on the Constitution, rightly and wrongly, as to what constitutes constitutionality and what is breaching. Yes, and how many constitutional rights exist because they seem to grow by the day. You know, and how many parts are being breached if you inject someone and that type of thing. And so, but most well-reasoned vaccine opinions end with the courts, that we can only have certainty through the courts. When the court opines, when the court rules, and it just brings home that through this time of uncertainty, the court is where one finds your certainty. Where it is that you can have the opinion of 100 legal experts, luminaries, associations, and so on. But at the end of the day, it is the ruling of the court that settles the issue. And so, it is even more important in times of chaos, times of uncertainty, for us to have these courts, both physical and virtual and in any way possible, continue to exercise its mandate of a timely delivery of a high standard of justice for all. And so, as Madam DPP has indicated, you know, we work in challenging times, in challenging conditions, and we are yet human. Every judge is human. Every judge feels the pain of the loss of a friend, the loss of a colleague, the loss of a family member. Every police officer, everyone who works, every prosecutor, everyone who works and is a part of the justice system, a part of any part, I said from top to bottom, feels that pain and still has to go forth and continue and try to represent their aspect of the justice system as best as possible. But I think in all of these, and one of the things that we have read about as well is the mental health aspects of these things. We must remember that even though we are just, we are not super. And we are not superhuman. We must push ourselves to our limits to uphold the standards of justice, but we must not push ourselves beyond those limits. We must recognize when those limits exist. And we should all see collectively to be a part of the solution. So where it is that problems arise in society, difficulties, uncertainty, and so on, we, as members of the justice system, as a part of the justice system, should all strive to be a part of the solution. We saw very, very recently a situation where someone who was supposed to be part of the dispensation of law perhaps may not have upheld it as best as possible and swiftly acted in recognition of that difficulty. And so we want to ensure that we do not have to fall upon our swords and that we are the ones who continue to light the darkness and uphold the rule of law for accused, for victims, for claimants, for defendants, for those who have complaints against employers, for the employers who have complaints against employees, for all stakeholders in our system. It is all held together by law, because outside of that, we are a system of chaos and we can go nowhere, and anarchy, and can make no advancement. And so the private bar, the Jamaican Bar Association, to play our part in upholding the rule of law, continuing to uphold the rule of law, in partnering with the justice system through you, Honorable Chief Justice, in finding the necessary solutions, in continuing to find the best ways to operate as lockdowns challenge the court calendar, as quarantines, as all manner of necessary measures are taken. We know that it can adversely affect other parts, but we will continue to work together to find the best solutions possible. Thank you.
Thank you very much, Mr. Lebo. Let me thank council who are present for the words of encouragement and condolences. Let me recognize those persons who are joining us on the various social media platforms. I'm not sure, but this is the first time that we are doing this. I think this is the first time that the opening of the circuit court is being live streamed. And I suspect it is a wonderful time to do this, because it addresses the whole question of access to justice and open justice, because it is something that we have to constantly think about as we go forward in managing the operations of the court in the context of the COVID-19 pandemic. And we have to solve the critical issue of members of the public being able to see, hear, and observe what is happening in their courts. And I say their courts deliberately to pick up on what the learned director has said, that we're all here to serve members of the public. And so this morning began with a somber note when I received word of the passing of His Honor, Mr. Horace Mitchell. I know that he was hospitalized and battling with the COVID-19 virus for quite some time. It is the second judicial officer that we have lost in the last 4 weeks, the first being His Honor Mr. Stanley Clark. And it has really brought home to us the immediacy of this disease and how we really can't be too careful. And I knew both judges personally, Mr. Clark for perhaps near onto 30 years, and Mr. Mitchell for approximately the same time, because I met him when I went to Manchester as a prosecutor. In fact, one of my first cases in Manchester, where I was junior to the now director, Mr. Paula Llewellyn, were prosecuting a gentleman who was charged with significant offenses under the Dangerous Drugs Act. And so Mr. Mitchell was there in the court as an assistant clerk. And over the years, he rose to become a judge of the Parish Courts, a very experienced and dedicated public servant. And so too Mr. Clark, whom I knew from his time in the Attorney General's chambers. Then he was at the Ministry of Health, and then he became a judge of the then resident magistrates court, and so certainly one of the most experienced judges that we have had in the parish courts. So the loss of both gentlemen is a severe loss to the judiciary, and we offer our condolences to their families, to their friends. and well-wishers. In the midst of this, remember members of the bar who have passed on as well, and the Jamaica Constabulary Force and other persons within the court family who have all lost persons, whether parents or siblings or uncles or aunts, extended family members, to the COVID-19 virus. So I wish on behalf of the judiciary to express our condolence to the families of members of the bar, the Jamaica Constabulary Force, persons within the courts who have lost family members, and to remind us that as we mourn and we grieve, we store the memories that they brought to us, the pleasant memories that they brought to us, and may their contribution to our lives be long-lasting. And it's a reminder of how fragile this gift of life is, because it really is a gift. And it is particularly sad for me because in following the reports about His Honor Mr. Mitchell, we were optimistic that he was recovering, and we were expecting that he would have been able to be discharged from the hospital within a short time. But then the news came that he passed, and so that has really come as a very hard blow to me personally and to judges here in the judiciary. So with those opening remarks, I now turn to the matter at hand, which is the opening of the legal year, the Michaelmas term of the Supreme Court and the Court of Appeal. And it's one of the sad things about this disease that Mr. Champagne has mentioned, where you really don't get the time to grieve. You just have to be moving on from one event to the next, not in an uncaring way, but things just have to be done in order to keep the courts open and for attorneys to discharge their very important responsibility. I know that when the pandemic first struck, and I had said that the courts are an essential service, and persons were wondering, well, why is the Chief Justice saying that the courts are an essential service? But it is more than essential service. So in that respect, I was wrong. It was really an understatement. It is really a constitutional right that persons have in order to be able to have access to the courts. And we in the courts must make every effort to keep the courts open and to have persons being able to seek legal remedies, because life simply does not stop. The law is being enforced, whether in the public sphere through police action, persons are in custody, bail applications have to be heard. There are persons who, because of their loss of employment, are having their residential security threatened. Lenders wish to recover their money. Court has to balance the interest of the lender as well as those who are in the property. You have persons who are victims of domestic violence. You have children who are in conflict with the law. And so all of those things are happening while the pandemic rages around us. And so these things can only be resolved in the context of the courts. And I wish to use this opportunity to express my gratitude to all the support staff, all the court staff in all the courts, because they have done exceedingly well in these very, very difficult times. Many of them traveling significant distances in public transportation, sitting next to persons who may very well be unmasked, and you really don't know whether they have the COVID-19 virus or not, but yet they have come out every day that the courts are open, and have contributed to the rule of law and the stability of our democracy. And so when we speak about these things, they sound like lofty phrases, but you look at the societies where there's an absence of the rule of law, and then you will see how important the courts are as a dispute resolution mechanism and to balance the rights of all the persons and to provide an outlet for persons to have their rights and obligations determined. So I wish to thank the court staff for the dedication that they have shown. Thank the judicial officers as well, and I use judicial officers now broadly, including the registrars who carry out some adjudicatory functions, and they too have demonstrated their commitment to the rule of law and to preserving our democracy. So I wish to thank all the judicial officers in Jamaica and all the persons who work in the courts for the sterling work that they have done over the past 15 months or so since the pandemic first struck in 2020. Thank you very much. Yes. Now, when I had spoken at the Assize services last year, and I said that we really don't know how long the pandemic will last, I must confess I did not think that 1 year later we would still be in circumstances where jury trials cannot be safely resumed. And we have, just to assure members of the public and to members of the bar, that the decision not to have jury trials recommence this term is one that was not taken lightly. It came after thorough discussion and examination of all the possibilities. Now, we know that at the Home Circuit Court here we have 2 courts that have been fitted to accommodate jury trials, but when all things were taken into account, including and in particular the spike in the COVID-19 numbers, the Delta variant, which unfortunately seems to be very efficient, some would say too efficient at what it does, the decision was taken that across the island we could not safely resume jury trials. We felt that it was just simply too risky, particularly at the point of jury selection where the jurors would have to be certainly in one space where they could see and hear what is happening and hear the names being called and so on. And also the jury boxes are simply not large enough. The question came up of having the jurors sit in the well of the court, but again, the courtroom designs are not conducive to the jurors seeing the witnesses. Then the question of where would the witnesses be if they were giving evidence? So a lot of factors were taken into account when the decision was taken. And this wasn't taken just by the Chief Justice, but it is what I call the COVID-19 Advisory Committee that involves the judges from the Court of Appeal, Supreme Court. Well, the judges from the Court of Appeal are represented through the President. They have judges from the Supreme Court, from the Parish Courts, members of the bar through the various bar associations, the Department of Corrections, the Jamaica Constabulary Force, we have the Court Administration Division, we have persons from the Attorney General's chambers who attend from time to time, and just about every stakeholder within the justice system. So it is a broad-based committee, and it meets from time to time to review and to discuss the whole question of how the courts should be operating in this time, and in particular the criminal courts, because we are acutely aware that there are many persons who are in custody awaiting their date of trial. Now, I think so going forward, I think we just have to accept that the COVID-19 will be here for quite some time. And so we have to move now from response to the crisis to having more permanent and settled ways of managing within the COVID-19 pandemic, or indeed any other pandemic that may come. And so beginning with the design of juror boxes, I think we'll have to redesign them across all the courts. Certainly we have to make them large enough so that they can accommodate the recommendations of the Ministry of Health, because one of the things that we found is that when we went through all the courts in Jamaica, we found just about 2 here at the Home Circuit, 1 in Portland, 1 in Westmoreland, that could actually operate within the guidelines of the Ministry of Health without significant alteration. All the other juror boxes in all the courts would have to be extended significantly to have the 7 jurors at the recommended physical distance, and also have additionally now the barriers that would be placed between each juror. So that is significant capital work that will have to be undertaken as we go forward to manage the jury trials in our courts. Now, I spoke about the work of the judges and the support staff within the courts and what the data is telling us, certainly the annual report and the report so far this year. The irony of it is that seems as if 2020 has been one of the most productive years in the life of the court. And so we have the Court of Appeal improving its delivery and rate of delivery of judgment significantly, falling just about 3 judgments behind where they needed to be as far as the strategic plan is concerned. We have the Supreme Court of Jamaica improving in its rate of delivery of judgments, delivering 234 judgments for every 100 reserved. And so we are on track for all outstanding judgments to be delivered by the latest March 2022. So that would be a significant development in the life of our courts. You should also know that as far as the gun court is concerned, the one here in Kingston, it is the first court, I mentioned this yesterday, but it is the first court to meet international standards as far as performance is concerned. It has 10% of its, the gross backlog now, 10% of its caseload is in backlog, and 5% net, that's it. 5% is the net backlog of cases in the gun court. And so that is in keeping with the international norm. And so the question now becomes transitioning now from reducing the backlog to maintaining that level of performance throughout. And here, that would not be possible without the cooperation of all the stakeholders, the police, members of the bar, the prosecution, witnesses, the Department of Corrections. All of you played a very vital role in enabling us to achieve that significant milestone. So to the Revenue Division of the Gun Court, of the Supreme Court, or the Revenue Court, by October of this year, all of its cases should be current, and we wouldn't have any cases that are waiting now for judgment to be delivered. So that would mean that 2 of our courts would have met international standards as far as the delivery of judgments is concerned and clearing the backlog. And that is a very significant development in our legal history. Now, going forward, for this term, we'll be introducing for the first time and another division. This is the Family and Probate Division that is to commence today. And we're also emphasizing with a team of 3 judges the assessment of damages and the trial of simple negligence cases. Because what the data is telling us, certainly on the civil side, we have been doing such a wonderful job there. Cases were being set 2027 and 2028. Now, we have set our time standard at 24 months, so you can't have a time standard of 24 months and you're setting cases in 2027 and 2028. So what we decided to do was to begin the process now formally and in a structure there, what we call differentiated case flow management. Something that we have been doing in the sense that all courts process cases and have them flowing through the courts. The difference, however, is that this is more targeted and deliberate. So cases are now going to be categorized using criteria developed by the judges. We're having simple, standard, complex, the broad categories, and the whole idea being that simple cases go through faster than the more complex cases. What we have tended to do was to list the cases according to the time when they came into the court. So if the complex case came in at number 1, then that would be the first. And if a simple case came in at 2, then it joined the queue behind the complex case, even if the simple case could have been disposed of in a shorter space of time. We have found that that is not the best use of resources and time. So we are now moving formally now to differentiated case flow management, and the manifestation of that now is with the establishment of the Family and Probate Division with 2 judges who are assigned there. And so essentially what will happen is that all the matters related to the dissolution of a union, usually the big 3, maintenance, custody, division of property, those now will be taken out of the HCV list and placed now on in their own resource. We have the 2 judges there who will be having full control over those cases. So they will now have essentially a clean slate to manage those lists and to set the dates and manage the case and see them right through to completion. So this is a 2 to 3 year project. So during that time, the judges won't be going off to circuit and doing any other kind of matter other than these matters. So we are doing the same thing with the assessment of damages and simple negligence cases, where we are assigned a team of 3 judges to deal with those cases. So what we have found is that after the default judgment was entered, then it was up to counsel now to indicate whether they were ready for trial or not. But oftentimes, in terms of the assessment portion, but oftentimes when the assessment trial came up for hearing, counsel wasn't ready. And so we had a very, very high rate of adjournment. So we decided that we'll be taking a different approach. And so what that will now involve is that the judges will be examining all of those cases to determine whether or not they are ready for hearing. And where we want to get to ultimately is that no case gets onto the trial list until it is in fact ready to be heard. And we'll be doing a similar thing for the Other cases in the HCV division, the civil procedure rule speaks to either setting a trial period in the CPR or setting a specific date. So we want to move away from setting specific dates because, again, what we have found is that about 40% of the cases set for trial at case management are actually adjourned, even though they are set 3, 4, 5, sometimes 6 years in advance. So it is now a matter now of looking at those cases more carefully, managing them more effectively, so that you only get on to a confirmed trial date when the matter is in fact ready for trial. Which the other side of the coin is that when it comes to adjournments now, the judges will be taking a less charitable view of adjournments, because in the end, the persons who really suffer are the litigants, not the lawyers, except insofar as fees may be concerned. Not the judges, but the litigants. They are the ones who are waiting a very, very long time. And 5 years or 6 years, in some cases 7 years, for a matter to be heard is just simply unacceptable and intolerable in any legal system, especially in the 21st century. So those are the active steps that will be taken now to address and arrest this difficulty. So those are the significant developments for the coming term. So what we'll be asking now is for the cooperation of all concerned to ensure that whatever event is to take place on any particular day, whether it is a bail application, whether it is a case management, whether it's a pre-trial review, whatever it is, that we make every effort to file the documents in time, to have the staff being able to get the documents to the judge in time, and for the judges to be prepared so that the actual hearing or the event can go on. And so in that way, we will actually get to the point where our cases will be disposed of in months rather than years. It is happening in the gun court here, and it can happen in other areas of the court. And I just wish to mention the parish courts, because those courts of the 3 levels of courts, they are the least resourced, but certainly has proven to be among the more or the most resilient of the 3 courts. And I say this because the data is telling us that, certainly on the criminal side, 92% of the cases are actually disposed of in 24 months or less. That's what, so after 4.5 years of data from August 2016 to now, that is what the data is telling us. The same thing occurs on the civil side of the parish courts as well. And so where we are now is that the second quarter of this year has demonstrated that those courts have exceeded even what they did in 2019, the year before the pandemic. So a lot of work is being done in those courts. And we'll be enhancing their productivity by ensuring high-speed internet connectivity. It's a project that is being done in conjunction with the Ministry of Justice. And certainly by the end of the year, the work should be done that all of the parish courts should have high-speed internet connectivity, and will be able to facilitate more efficiently remote hearings and also increased access to justice. So what this means for attorneys is this: unless you so choose, you won't need to be driving from Kingston to Montego Bay to apply for an adjournment. You'll be connected to the court and it can be done. It means that attorneys won't be traveling from Westmoreland to the Court of Appeal or to the Supreme Court to spend 5 or 10 minutes before a judge in the criminal courts. So all of that now is designed to increase access to justice, increase efficiency, reduce time, and to make life easier for all concerned. And just one thing, I will be encouraging the police. We didn't discuss this with them before, but I think we now have to consider some of the police stations of having some kind of bail centers where persons who are on bail, if the matter is a mentioned date, why should they be traveling significant distances to appear in the court for 5 or 10 minutes? Oftentimes, when you have when bail is granted, they are prevented sometimes from living in the communities of origin and have to move to significant distances away from where it is alleged that they were involved in some crime or another. So I am thinking that we need to get to the point where if the person has an offense charged in Portland and is now relocated to, say, Westmoreland, why shouldn't the person be able to go to the police station or some appropriate place in Westmoreland and appear electronically for mentioned dates, and so you really only turn up in the court when the matter is for trial? So that is where we have to push on to. And ultimately, for the correctional facilities now, get to the point where you can have situations where the defendant remains where he is and the trial takes place. Now we still have to solve the problem of counsel being able to communicate in a safe and secure manner in terms of and having full regard for legal professional privilege. But I have no doubt that with the collective wisdom of all of us, we'll be able to solve those problems. Now, while I'm a fan of technology, but it is not necessarily appropriate for all cases. One of the challenges that came out in the recently concluded Commonwealth Magistrates and Judges Association conference was conducting remote hearings while still preserving the dignity and the solemnity of the proceedings. There was an anecdote told during one of the presentations where in Trinidad, a family matter was going on. So one of the participants was there pacing in his backyard with his phone, because that is where he said he could have steady connection. But he forgot that it was still a formal hearing, and I think the judge's patience snapped when he took out his cigarette to have a smoke. And the judge said, well, I think enough is enough. And so his participation in the proceedings ended abruptly. So it is really managing situations like that. We heard of instances where a judge in England was conducting a hearing and he was struck by the level of detail that the witness was able to give without pause. And he was saying, but this is absolutely remarkable. Further inquiry revealed that the witness had some kind of board with the information written on it that he could glance at from time to time to give his answers. So it is solving issues like that, so we don't have the integrity of the process being undermined, that we have to think about and resolve as we move forward with the technology. So while it is good, we have to recognize that there are pitfalls, we just have to solve them. So, and they're not, and the remote hearing is not necessarily appropriate for all types of cases. Types of cases will have to be selected carefully, and as we go forward, now we have to begin to look now at the features of what we have been doing that we can keep and make permanent, and those that we may have to abandon because we must always seek to ensure that the proceedings are fair, that they have the appropriate degree of solemnity, have the appropriate degree of formality that is required, and to ensure that when the witnesses speak, it is really their evidence, unprompted and unaided by any illegitimate, from any illegitimate source. So those are some of the things I wish to share with you this morning. Let me thank you all for being here. Let me thank the CAD, especially the ICT department, who I must tell you have done outstanding work over the past few months, because as you know, they're operating on a shoestring budget, and they have been able to do absolutely remarkable things, keeping the courts connected. I'm fully aware it hasn't worked perfectly at all times, but I think substantially it has worked. There have been delays and so on, but they have done really an outstanding job in keeping the courts connected, enabling persons to participate in hearings. And so I wish to thank them personally for the work that they have done. You have their director here, Ms. Ashman, who is sitting in court overseeing proceedings. A lot of what the court is now engaged in could not be accomplished without effective communication. So I have Mrs. Jared Fletcher, or we'll just call her for short, our Director of Communications. She's sitting here in court as well, and she has assisted us in communicating with the public about what is happening with the courts and why we are doing what we are doing. And now that we are here integrated in the way that we have been with CAD, it makes you wonder how, as a judiciary, we have been able to survive all this time without an entity such as the CAD, which is dedicated solely and exclusively to assisting the judiciary in discharging its functions. So I wish to thank the persons, the Court Administration Division, led by Mrs. Cameron Anglin, for the support that they have given us, particularly over the last few months, beginning in March of 2020. So I thank you all very much. And so it remains for me now to thank the court staff who have been here, our court reporters who are laboring under trying conditions with shortages of equipment, malfunctioning computers, malfunctioning steno machines, and they too, like the rest of us, have been the victim of disruption in the supply chain. So the computers that we have ordered, they haven't yet arrived, and our supplier tells us that he is also a victim of the disruption of the supply chain globally. And the price mechanism is being used to allocate spaces, cargo space on ships. So while the cost of the equipment itself may not have increased significantly, but insurance and freight, that has seen significant increases. And so it has delayed the arrival of the equipment as far as the steno machines are concerned now. We have now been advised that the machines that the writers now have, when we were inquiring about whether there were persons who repair these things in Jamaica, well, we don't have any. When we inquired of the manufacturers, whether they repair these machines. I won't say the gentleman burst out in a fit of laughter, but I just simply say that he said that no, we don't repair these machines anymore. And the question of having someone to come here to repair them was definitely out of the question. So this really is talking about new machines. And that seems to be the way of the industry. You have your machines for a finite period, and then you move on to the next generation of machines. So that is where we are as far as the court reporters are concerned. So we thank them for the work that they have done and working and producing transcripts in trying circumstances. So thank you all very much, and we look forward to the cooperation of all. We're operating in a very volatile, unpredictable world. We never know what will happen the next day. Maybe it is fulfillment or manifestation of what was it, the ancient philosopher Heraclitus, who said the only constant is change. And so it is. And so we have to be agile and adjust, and to know that for many of us, it is very disconcerting. Human beings, even the most optimistic of us, we like some degree of certainty, or at the very least, continuity of the status quo for some period of time. The COVID-19 has brought home forcibly to us that may be just a wish for the time being. And so it is important, and I urge everyone now to pay close attention to your mental health, your emotional health, the mental and emotional health of families, friends, those persons that you have thought of that you haven't called. Just pick up the phone and call them. How are you doing? What is happening with you? Reach out to your neighbor, reach out to your colleagues, particularly those who you know live alone. It's very important that we do that to ensure that we keep in contact, because human beings were designed to be in contact with each other, even the grumpiest among us is designed to be in contact with another human being. So let us have an exercise regime, eat properly, and do the things that will help us to relax so that we can cope with the difficult times that we are in. So thank you all very much, and we'll resume tomorrow or on Monday. I think Madam Registrar in this court. So we'll resume on Monday when they expect that we'll get to the matter of Mr. Bryan and others. So let us adjourn, please.